right, good afternoon, or I guess good morning. Welcome to the first webinar of the Legal Issues Committee for 2019. My name is Jared Eade. I'm a partner at Holt LLP and the chair of this year's Legal Issues Committee. We're very excited to kick this year off with a awesome webinar with some great panelists with some very interesting topics this year. We're going to be talking a little bit about what the CFPB has been doing, about a new case that Severson has been handling, Hoang versus Bank of America, some Privacy Act issues, as well as a labor law update. And I'll tell you, this leads into some really exciting stuff of what we're doing this year for 2019. Most importantly, though, I should say, is that the 2019 brings a change, which is we have a sponsor for our webinars. And Susan, if you would like to lead us into that, I want to say thank you to our sponsor.
Yes, thank you very much. Next slide. I'd like to thank our Legal Issues Committee sponsor for this year, Wiener Brodsky Kiter. Cybersecurity is front page news. Data breaches are a persistent threat to financial institutions, and state and federal regulators have taken notice. Most companies rely on their information technology departments or IT vendors to keep their information and their customers' information safe. While strong IT is necessary, however, it is not enough. Data security and breach response needs to be fully integrated into your compliance management systems and enterprise risk management. Wiener Brodsky Kiter has provided legal services to the financial services industry for 3 decades, and they are at the forefront of cutting-edge issues. Their team of highly skilled attorneys has helped clients through the toughest issues, including integration of data security compliance, and they are proud to sponsor today's event for the California MBA. Back to you, Jared.
Excellent. So we're going to start off, first off, with throwing it back to you, Susan, with the legislative report of what's going on in California's legislature, what they're working on. But before we begin that, I'd be remiss if we didn't mention the California MBA's activities in trying to influence what's happening in Sacramento. The most important being, just coming up in about a month from now, is the California MBA's Legislative Day for 2019, March 18, 2019. It is a not-to-miss date, particularly important as we deal with this year's legislature and what they're going to be trying to do to influence our industry. It's our opportunity to influence back. And Susan, I know you've got some more details on that. So why don't I turn it back to you with some updates on what they're doing and how we can be a help and service in preventing it from being too bad.
Excellent. Thank you, Jared. Next slide, please. Before I get into the 2 bills that I'm going to talk about, I just want to expand a little bit on what Jared has just shared. We have our annual Legislative Day coming up on Monday, March 18th in Sacramento. This is our most important event of the year in many ways because it is our opportunity to have real estate services professionals in front of the policymakers that are going to be voting on bills that are of great interest to us. And so it's just a 1 day out of the office for those of you even in Northern California. You can drive in that morning. Very easy to participate in. We do some content on our legislative issues over lunch is when the event starts. We set up, you will go into teams over to the state capitol to participate in meetings with key members of the Senate and Assembly banking committees. And then we end the day with a legislative reception. But again, great opportunity for some one-on-one with our key policymakers. Also want to share with you that during our Legislative Day luncheon, we're going to have a presentation on the consultant that's working on the tax on services issue. This has been a legislative proposal that's been introduced several times in the legislature and has been defeated, but with a new governor, the proponents of instituting a tax on services in California has become more significant. As you know, our governor, as soon as right after the November election, talked about the importance of tax reform, and this is going to be one of the items that is going to be priority for him. So you can join our Legislative Day to also find out what the California MBA is doing to be a part of the effort to work against instituting an additional tax on services in our state. So with that, I'm going to go into the two bills that I did want to talk with you about. First is AB 25 by Assemblymember Chow. This is going to be, it's kind of, it's just a placeholder bill at this point, a spot bill. It will contain content as it's amended to make some changes to the California Consumer Privacy Act, as we all know was passed last year. There's probably going to be a handful of bills that will attempt to make some changes in that legislation. The Attorney General has been tasked with the rulemaking process for promulgating these regs, and is currently holding some public forums across the state to gather information from stakeholders. They have announced that they will be formalizing their rulemaking process in the fall. However, the look back period at this point begins July 1 of 2019. So it is definitely an issue that we all need to be paying close attention to. The major areas of focus that we're looking at, we want to see clearer and more narrow definition of consumer in the bill. We want to remove the business-to-business potential coverage relative to the definition of consumer, narrow the definition of personal information, and reduce the requirement to provide specific information for consumers upon request to make it more reasonable for businesses to comply. We are in conversation with the author and are part of a larger, coalition of people in the business community to be working on this important measure this year. So we're currently just monitoring this bill for its next amendment. Next slide. AB 199 is a bill that is similar to a bill we sponsored last year, which would create remote online notarization in California. For those of you who were following this, we did have it introduced last year and was coming through the legislature pretty well until the Secretary of State had to come back and let us know how much they anticipated costing us to implement this, and they tried to tie their upgrade of their entire computer system to this bill. So unfortunately, it got defeated last year, but we're hoping to be working with the Secretary of State's office and the author of this bill, Assemblymember Calderon, to be able to create remote online notarization for our state. And those are the only bills that I have an update on now. We will be talking about more bills on future webinars.
Excellent. Thank you so much for that, Susan. I'm glad that we only had two that we needed to go over, but going from one particular hotspot to another, we're going to hear next from Rich Andriano about what's going on with the CFPB. So Rich, why don't you let us know what we're looking for in 2019?
Thank you very much. And what we have first going to address quickly, the first FAQs issued under the TRID rule, and there are 4 of them. And I think probably there are really 2 of them. The last 2 are really the key ones, and they really, I think, relate to the Economic Growth Act that was passed over the summer. What the first FAQ does is it just reviews the timing requirements for a revised closing disclosure. We know what those are, that in general you don't have another 3 business day waiting period unless one of 3 things has occurred. The APR is inaccurate, and that's the key for purposes of the FAQs that follow. The loan product or certain loan feature change or prepayment penalty is added. If you have any one of those changes, you need another 3 business day waiting period. Now let's look at the next slide. And what they do here is they address specifically what happens when the APR decreases and becomes inaccurate. What the Bureau noted, as they have before, is there are some tolerances, and if the APR changes but stays within the tolerances, it's still deemed accurate. They cite the Reg V section, which incorporates the statutory tolerance of 1/8% up or down for regular transactions, or 1/4% up or down for irregular. And they also note the regulatory APR overstatement tolerance, but that's a conditional tolerance because it's tied to an overstated finance charge, and the APR cannot be overstated by more than the dollar equivalent of the finance charge. Because of that, a lot of investors don't allow lenders to rely on the APR overstatement tolerance, and some of them also don't allow reliance on the broader 1/4% tolerance for irregular transactions. They sometimes require 1/8 of 1% up or down for all transactions. Because of that, there was a need in the industry to try to get some change. And that's what the third factor addresses, and we'll look at the next slide. What the industry did is they went to Congress, and they got Congress in the Growth Act to have a provision, no wait for a lower rate, and the intent was to have an amendment that wouldn't require another waiting period when the APR becomes inaccurate because of a decrease. Problem: Congress amended the high-cost mortgage provisions. It didn't amend the more general waiting period provision in Section 128, which was part of the authority that the Bureau used to adopt the closing disclosure waiting periods. So, question to the Bureau was, Bureau, did the Growth Act change the TRID rule waiting periods? And the Bureau's response was no, because it amended the high-cost provision, not Truth in Lending Section 128. That was really a disappointing answer because we know what the intent of Congress was here, and the Bureau really should engage in rulemaking here to reflect the intent of Congress and eliminate the need for a second waiting period when the APR decreases and becomes inaccurate. And we'll have to wait to see what happens there. But let's move on to the fourth FAQ on the next slide. This addresses an issue with the model disclosures to the TRID rule. As we know, there are blank loan estimates and closing disclosures, and there are completed versions. Not long after the TRID rule was adopted, we in the industry found out that some of these completed disclosures, which are very important because they have a lot of the substance that you need to complete items that are in the rule. They really show you how to do it. But in some cases, it appeared the forms differed from the literal TRID rule requirements. That was brought to the attention of the Bureau, and they first informally said, well, you can't rely on those completed forms. And then actually in 2016, when they proposed what would become TRID 2.0, proposed to do just that, say you could not rely on the completed forms. That was very significant. Let's move to the next slide, and what happened there is the industry, including Fannie and Freddie, greatly objected to that proposal that we couldn't rely on the completed forms. So the Bureau didn't go forward with that, but it also didn't amend the completed forms to reflect the TRID rule as it was now even being amended. Industry was further concerned. Now you had the forms that were 2 iterations away from the TRID rule, so they went to Congress trying to get some help here. And what Congress did in the Growth Act was direct the Bureau to provide guidance here. This FAQ appears to be that guidance. What they do is they do confirm that both the blank forms and the completed forms are in fact model disclosures, which if you rely on a model disclosure and you use the right one, that's a safe harbor for compliance. So they do confirm that. Now, in the next slide, what they also note is that, look, to the extent you use the appropriate form and you provide accurate context, you meet the safe harbor, even if the model form doesn't reflect the 2017 amendments. They provide an example. 2017 amendments clarified some garbled language so far as when you truncate to an even number when they're just trailing zeros to the right of the decimal spot. One of the forms, however, shows prepaid interest as 4.00%, not 4%, just the whole number. The Bureau said either disclosure is permissible. So it's helpful, but what would really be helpful is if they update the completed forms to reflect the rule. Now let's move on to the next slide, the reassessments. First, the ability to pay rule and the servicing rule. Just very quickly, both are very underwhelming here. No cost-benefit analysis at all. The Bureau does acknowledge that the rule's effect on lending might have been greater had not lending already been constrained when the rule was adopted, but it doesn't really think it increased cost that much, but it acknowledges that perhaps there are foregone profits because people aren't making certain loans. Look at the next slide, and where I want to point out one of the big points that they do make, which is on points and fees. I gave the whole quote so you have that for reference, but basically they don't see the points and fee cap as being an issue because they say when it does become an issue, lenders will generally waive a fee so as to be within the limit, and very rarely will they refuse to make a loan because of the points and fee limit. That's not the conclusion we wanted, and so we've got our work cut out for this to let them know we want some relief on the points and fee limit. Look at the next slide. They address the other big issue, the temporary GSE QM. And they note, well, what a surprise, the industry heavily relies on this because son of a gun, the robust non-QM loan market never developed. We all knew it wouldn't, and they acknowledge it hasn't and that the temporary GSE-QM is significant. What they don't do is address the sunset, which is January 2021, and that if that sunsets without something replacing it, we're in big trouble. And so that's a very significant, no sense of urgency on that point. Let's move on to the next slide, which addresses just that no specific proposal here. And what they really want, we anticipate the industry will react to this, and then we might propose a rule. It's very disappointing. Now, let's look at the servicing rule reassessment on the next slide. What they do note, no cost-benefit analysis. However, they address the significant increase in costs that have occurred, but they don't think it's based on the rule. They think it's based on legal settlements and investor requirements. Well, what the rule did was take a lot of those legal settlements and put the standards of those settlements into the rule. So it's a little misleading saying the rule itself didn't increase costs. Next slide. Here where we note they think it's helped avoid foreclosures, helped delinquent borrowers. 3 requirements they think have increased or been the most burdensome: the 5-day acknowledgement for loss mitigation applications, evaluating borrowers for all available options, and then providing a summary of that evaluation. And I've heard that is very burdensome. And next slide, which simply notes they really didn't make any proposal here. They simply are hoping industry input will inform future rulemaking. Last point on the next slide I'll cover, they finally adopted policy guidance, not a rule, which addresses what will be publicly released. They essentially adopted what the Cordray CFPB had proposed. People have said, gee, is Klinedinst, since she did that, is she going to be more like Cordray and less like Mulvaney? Said this and the assessments were almost done when she came in. I wouldn't read this as indicating what she does going forward. Let's look to this spring where they're going to propose HMDA rules and propose a rule on what's publicly released. That'll be probably our first key for how Klinedinst is going to run the Bureau as compared to Mulvaney and as compared to Cordray. That is all, and I thank you for your time.
Rich, that was phenomenally interesting, and I it's going to be interesting nonetheless to see how she does ultimately take over and what her leadership style is going to be come this spring. So, I hope you certainly can give us some updates on that later on throughout this year. So thank you very, very much. Up next, we have Elizabeth Holt Andrews with Severson Werson to talk about a very interesting case that recently came down at the end of 2018, Hoang versus Bank of America.
Hi, this is Elizabeth. This is a case that I argued in the Ninth Circuit in October, and the opinion came out in December of 2018. And as it's binding on the entire Ninth Circuit, including, of course, California, and we think it is fairly helpful to the mortgage industry in a variety of ways, which we'll explain. We thought we'd give you a little bit of an insider's view of the oral argument and the decision. So this case started life in the Western District of Washington. It was brought by a couple of homeowners named the Hoangs who were had fallen behind on their mortgage loan, their residential mortgage loan, and they sued their servicer, who is Bank of America, and the investor, who is Fannie Mae. We represented the servicer and investor at the district court level and managed to win at the sort of outset of the case. We got a motion to dismiss granted before the case really got anywhere. And the borrowers appealed up to the Ninth Circuit. As I said, that got argued in October, and the opinion came out in December. And if we could go to the next slide. Just to give you a little bit of background about what this case is about, it's a Truth in Lending Act case. And specifically, it is about the provisions of the Truth in Lending Act where if a borrower does not receive certain disclosures at the time of loan origination, they have the right to rescind their loan. As many of you may know, if they do get their TILA disclosures, they get 3 days to get buyer's remorse and rescind. If they don't get their TILA disclosures, then they get 3 years to rescind their loan, which is actually, it's a pretty draconian statute in that sense. You either get one piece of paper in your 2-inch stack that you're signing at origination, or you don't get it. And the consequences of not getting it are pretty huge. So if we could go to the next slide. If a borrower decides they want to rescind and they send in a piece of paper saying to their servicer saying, I want to rescind. And they say in there that I didn't get my TILA disclosures, and so it might be 2.5 years after origination, the loan may have been sold on to who knows where, but they still get to rescind at that point. So once they send in this piece of paper, the U.S. Supreme Court has said that's it. The loan is deemed to be rescinded as soon as they send that notice of rescission in. And, well, what happens then? The servicer then sort of has the job of taking steps to unwind that loan. They have 20 days to do it. Essentially, at that point, interest and fees stop accumulating, and the borrowers are supposed to pay back the principal. And that's sort of how it's supposed to work under TILA. What the Hoang case is about is what actually comes up fairly often is if the servicer doesn't actually take any action within those 20 days, the borrowers are sent in their rescission and then they just sort of keep making payments and the loan just keeps going. Or maybe the borrower's in default, but they've tried to rescind the loan. So can they be foreclosed on? It's not clear. So the Hoang case is about what is the borrower supposed to do if the servicer just doesn't respond. They just get this notice of rescission, they dump it in the loan file, in the servicing file, and nothing happens. What does the borrower do next? So if we go to next slide, the actual statute for TILA statute and the lead Supreme Court case interpreting it called Jezinoski, they don't really explain what the borrower does at that point. Presumably, the borrowers are going to bring some kind of lawsuit against the servicer and or investor to try and enforce this rescission notice that they sent in. But the question is, how long do they get to wait before they do that? Do they have to do it within a year of sending in the rescission notice? Do they get to wait as long as their loan lasts, which could be up to 30 years? When does their clock sort of run out to bring that enforcement lawsuit? The Hoangs in this case, they did send in their notice of rescission within the 3 years, as TILA requires. But then they didn't do anything for 3 more years. They just sort of, their notice of rescission was just sitting there. And eventually, after about 3 years, they finally filed a lawsuit against the servicer saying, hey, you were supposed to rescind our loan and you didn't do it. So if we could go to the next slide. Since there's no statute of limitations for these types of lawsuits, the Ninth Circuit sort of has to decide, well, does that mean there is no limitations period? You can just bring these lawsuits anytime? Or is there some statute of limitations that we can get from somewhere else and apply to this situation for this statute? The fancy name for going out and finding another statute of limitations is called interstitial lawmaking. Nobody needs to know that fancy term, but that's the technical name for it. Essentially, what interstitial lawmaking means is when you don't have a statute of limitations, you go to the state where your claim is, and you go swimming through all the state causes of action, whether statutory or common law, and you find an analogy, and you take the limitations period from that state law claim, and then you apply it to the federal statute. So that's what Hoang was doing. Is it was essentially a case where the Ninth Circuit had to go look around, and in this case it was Washington state law, and find a statute of limitations that they could use to import into TILA, which is of course federal statute. There is an exception to this rule that if there just is no good state law out there that is even remotely analogous, that you just can't make work for your federal statute, Then you get to dive into the U.S. code and go swimming around in there and try and find a federal statute of limitations that would be a good analogy. And the classic example of that is civil RICO. There's just very rarely a good state law analogy to RICO. So the U.S. Supreme Court actually has a case from the 80s, which says that if you want to bring a civil RICO lawsuit, we're going to use a statute of limitations from the world of antitrust, which is also federal law. So going to the next slide. So essentially, at work in Hoang was this sort of lawmaking exercise, and the plaintiffs argued in this case to the Ninth Circuit that if Congress had wanted TILA rescission enforcement lawsuits to have a statute of limitations, Congress would have put that in the statute. And Congress didn't do that, therefore there is no statute of limitations. And, so the only limit on bringing these enforcement lawsuits is the life of the loan. It's typically a 30-year mortgage loan. That has some pretty dire consequences for the mortgage servicing industry, because as soon as that notice of rescission gets sent in, as long as it's sent in within 3 years, interest stops accumulating and the borrower is only on the hook for principal at that point. So if you send in your notice of rescission within 3 years and then the servicer doesn't do anything and you don't do anything, if you got 27 years to sit there and keep on making payments, at the end of, say it's 29 and a half years into your mortgage loan, you get to file a lawsuit and say, hey, I rescinded, I want all my interest back for the last 27 years. Essentially, it would give them a free loan for 30 years. So it's a pretty dangerous argument if the court were to buy it. And in plaintiff's defense, there were actually 2 district courts elsewhere in the Ninth Circuit who had held that the plaintiffs could bring this rescission enforcement lawsuit anytime. And that was what these plaintiffs were trying to get the Ninth Circuit to adopt that viewpoint. So the district court went to the opposite extreme, that when the plaintiffs argued this in the district court as well as the Ninth Circuit. And the district court basically went straight to the exception and went to federal law. They said, we can't find a good analogy in Washington State, so we're going to go to federal law. Let's go find a federal statute that is a good analogy to TILA rescission enforcement. And they didn't have to look very far. They just looked in a neighboring section of TILA itself and found a statute of limitations for damages lawsuits. And that was a 1-year statute, and they sort of imported that to this situation. They said, well, the Hoangs sent in their rescission notice. They waited 3 years, and that's too late. They would have had to file their lawsuit within 1 year. So that was why at the district court level, the district court dismissed this case. So next slide. We go into oral argument in the Ninth Circuit, and it was a little bit of a point of contention internally at the firm and with the clients as to whether we should really kind of throw our arguments behind the district court's take on this. Obviously, we didn't want to do what the plaintiffs were saying and say there's no limitations period, but we were a little leery of saying, yes, the district court correctly went straight to federal law to figure out which statute of limitations to import, because that is really a very rarely used exception. And the truth of the matter is there's plenty of good analogies in Washington state law that the district court could have used. So even the morning of oral argument, I called my boss, who's the chair of the appellate group here at Severson, and we were still kind of going back and forth about how strongly do we urge the Ninth Circuit to adopt the district court's take on this. in the end, the Ninth Circuit kind of decided it for me, because as soon as I got up there, they immediately said, well, we don't agree with the plaintiff's position that there should be no limitations period. There's got to be some limitations period other than the life of the loan on these things. And we also don't agree with the district court's take, because we just think that you only go to federal law if there's just nothing workable at all in state law. And that's not the case here. So what they said to me is, all right, you're representing the servicer and the investor. We want to import a statute of limitations from somewhere in Washington state law. What state law should we use? So that was what they wanted me to talk about at oral argument. So if you go to the next slide, these were the sort of the different options that were discussed at oral argument. The first statute of limitations that the court considered was for quiet title. That was basically equally dangerous to us as if they had adopted the plaintiff's argument. At least in Washington state it would have been, because Washington state, unlike California, does not have a limitations period for quiet title. So it might have helped us elsewhere in the Ninth Circuit, but it would not have helped us very much in the state of Washington if the court chose to import the limitations period from quiet title. Judge Smith, who was the eventual author of the opinion, was pulling pretty hard for this one. He really pushed me hard about why they shouldn't use quiet title. What we wound up arguing, kind of putting our weight behind, was Washington state's sort of catch-all statute, which is the statute of limitations for, all claims that don't otherwise have one, which is a 2-year statute. And conveniently, in the Hoang's case, that would have meant that since the Hoang's brought their claims within 3 years, they would have missed the boat and their case would have stayed dismissed. So that's what we argued. The court didn't really give much of an indication about what they wanted to do during our argument, but when the opinion finally came out in December, they ultimately went with the breach of written contract statute of limitations, which in Washington is 6 years. In California, it's a 4-year limitations period. So eventually, what I think actually happened is Judge Smith, who was writing the opinion, really wanted to go with quiet title, and I think the other two judges on the panel, I think they sort of argued him down from that and got him to go with breach of written contract instead. So pretty happy they did that, because that could have been not a great outcome for us. So in the end, the Hoangs won their case in the sense that they got, if you could go to the next slide, they got to sort of get past the motion to dismiss. But in our view, this was a case of perhaps losing the battle, but very much winning the war, because we were able to get a published opinion that is applicable throughout the entire Ninth Circuit, the entire West Coast of the U.S., which essentially fixes this gap in the law about when you get to bring these lawsuits. It essentially it's governed by the state where the claim is brought, and for California, that means if you send in your notice of rescission, the clock starts ticking. You then have 4 years to bring a lawsuit to rescind your loan, and if you don't do it within 4 years, you're done. You lose that opportunity. So we're, on the whole, happy with the outcome, even though this case has now gone back to the Western District of Washington. So I think I'm right at my time limit, so I will stop talking now.
Excellent, Elizabeth. Thank you so much. That's a very interesting issue that, of course, raises the specter of having a different statute of limitations for TILA federal claims in every single state. So it'll be interesting to see how it shakes out. Next up, we've got a very interesting take on yet another state law specific issue, the California Consumer Privacy Act. Presenting this will be John Jaffe from Meyer Brown. John, why don't you take us away?
Thanks so much, Jared.
I'm going to start with a little history. Most of you know it, some of you don't, and I think it's interesting and instructive to have the history. This statute or act arose as a result of a referendum that a wealthy California real estate developer and investor paid for. He basically paid, story is $4 million out of his own pocket to get the referendum on the ballot. And the reason he did it, he was at a cocktail party, may have been at his own home, and was talking to a Google engineer and was just jokingly asking about what kind of information they have on him. And the Google engineer said, "You have no idea. We've got everything. And there is no privacy." And that got him to thinking and researching, and he was shocked by what he found, thus the referendum. The reason it wound up as a statute through the legislature is when the industry saw what the referendum did, it was terrible. It would have just been a huge nightmare. Not that the CCPA is not a nightmare in and of itself, but the referendum would have been worse. And the problem with referendums is you can only modify or amend a referendum by another referendum. Whereas with legislation, at least, you can go back to the legislature and get changes legislatively, so much easier to do. That's the reason we have what many people believe is a nightmare piece of legislation, and probably is. The other point is that there's very little in the way of legislative history. This bill was enacted took 7 days from beginning to end, essentially, from the time that the first draft was penned until it was passed. 7 days. Not much time for ledge history. Of course, without ledge history, we don't have something to turn to for explication or interpretation, which makes it even worse because the bill has a lot of ambiguities and uncertainties in it. Many issues remain unclear, and perhaps most importantly, the CCPA has been copied by at least 6 other states. There are 6 states with copycat versions of the CCPA on their legislative agendas this year. Could be up to 9 depending on how you count, but at least 6. There's another one with a GDPR-like bill. So we are going to see a proliferation. And the problem with that is, as you get variances from state to state, you're going to have sometimes possibility of not being able to comply with the statutes of all states. It just will, from a systems perspective, may be difficult or impossible. So, get ready for a wild ride. Okay. Can you skip ahead to slide 7, which is who does it apply to and what is expected? There we go. And I'm skipping ahead primarily because a lot of you are going to say, or have already said to yourselves, it doesn't apply to me. I don't care. So let's look at that first. Who does it apply to? For-profit businesses that meet one of 3 categories, that fit into one of 3 categories. Gross revenue of $25 million or more. They receive or share information of more than 50,000 California consumers, households, or devices annually. And as we'll see in a few minutes, the concept of consumer and household broadly defined, or who receive at least 50% of their annual revenue from the sale of California personal information. So some of the smaller mortgage bankers and service providers may say, that's great. I don't fit within any of those categories, so I don't have to worry about it. Not necessarily. If you are a subsidiary of or a parent of an entity that is covered under the law, then you too will likely be covered. So you can't just look at your own financials. You've got to look at parents and subsidiaries also to see where their income is derived and what kind of data they get from various entities. There are a number of statutes, and this again is a reason that many people think I don't have to worry about it, because one of the exceptions is if you have personal information that you collect, process, sell, or disclose, quote, pursuant to, close quote, the GLBA. And most mortgage bankers, be they originators or servicers, think all of my data is GLBA data. Not necessarily correct, and you have to look at whether or not that data was collected, processed, sold, or disclosed pursuant to the GLBA. None of us know what pursuant to means in this context. We're not sure why they didn't use the language, for example, in accordance with the GLBA, because arguably, when I'm collecting data, I'm not collecting it pursuant to the GLBA. I'm collecting it pursuant to my business needs. It just happens to be I'm doing it in accordance with the requirements of the GLBA. So we've got that one ambiguity. What does it mean to be pursuant to? And second is, what about the data that we collect that's not GLBA data? And a lot of the data that we collect as lenders or servicers or service providers is not necessarily non-public personal information under the GLBA, which means then that it's not covered or it's not pursuant to the GLBA. You then have to go into your database and start figuring out what data fits within this GLBA category and what is outside of it, because that data which is outside of it is then going to be covered by the CCPA. And by the way, there's similar exceptions for HIPAA, FCRA, and Driver's Privacy Protection Act, but the one that most of us care about is the GLBA. We are trying to get some explication either through the legislature or, failing that, through the AG. The AG has indicated that it will issue regulations probably sometime in the fall of this year. And since the law goes into effect when the final regs are published or by July of 2020, let's assume for the moment that they get the regs published in December, October, November, December of 2019, at least those published for comment, and it takes a few months for them to get finalized. It's not going to give people a lot of time to get their system set up to comply. In fact, I suggest it's not going to be nearly enough time. Next slide, please. Okay. A couple other things to which it doesn't apply. There's a carve-out if you have to maintain the data to remain in compliance with federal, state, and local laws. So, for example, if your state regulator says you must maintain this data for our purposes, and a borrower says, I want you to delete that, you don't necessarily have to delete it because you have to maintain it, assuming you have to maintain it legally for your regulator. There's also an exception for de-identified or aggregated consumer information. There's a caveat I'll give you here. If it's de-identified or aggregated, but it's easily re-identifiable through reverse engineering, you may have a problem. So you may not be out from under simply by de-identifying or aggregating it. Furthermore, nobody really knows what it means to de-identify. There are not clear parameters around that. Another exception is if all of the aspects of the transaction occur outside of California. That means the California consumer was outside of California when you collected the data. No part of the sale or transfer or conveyance of the personal information occurred in California. And no personal information was collected while the consumer was in California. How do you determine all of that? That's really the question. I think that is effectively an exception that has very little meaning. Okay, next slide, please. So what are the rights of consumers? First, there's a right to know what information is being collected and whether it's being sold, who it's disclosed to, etc. They have a right to access the information that you hold or that your third parties hold. So your service providers, for example. The most important, or maybe most publicized right is the right to be forgotten. That is the right to request the deletion of personal information, again, subject to certain exceptions like the need to comply with legal obligations. There's an opt-out and opt-in. So you have the right, or the consumer has the right to prohibit the sale of personal information. That's an opt-out right. And they have the right to authorize a sale as to individuals who are 16 years or younger opt-in. That's not going to matter for us so much. We're not dealing with people under 16 or less. But it will matter for some of the service providers, and certainly it matters for people like Google and Amazon. Next slide, please. Okay. There's a right to be free from discrimination, which is the right of a consumer who exercises the right not to be charged a different price or rate, or provide a different level of services, or to be denied goods or services. So, for example, if you have special deals for customers because you've collected their information, you think you're going to make some use of that information beyond the actual transaction, they have the right to come in and say, we want you to delete the information, and by the way, you can't change the terms, even though the deal that we made with you at the beginning was premised on your use of our information. You cannot now discriminate against us because we're exercising this right to have the information deleted and to not have it shared with others. There are some carve-outs to that, such as businesses may offer financial incentives to collect, sell, or not delete personal information. That will, of course, entail potentially significant changes in the way in which you collect information that you do intend to sell or share and monetize. There's a private right of action, but only in the event that the consumer is subject to a data breach. Next slide, please. Which brings me to enforcement. The primary enforcer is the California AG. California AG can assess a penalty of up to $2,500 per violation, $7,500 for intentional violations. However, the AG must provide written notice of the violation along with a 30-day period to cure. As I mentioned before, the private right of action attaches only for security breaches. So all of this is quasi-good news. It means the plaintiff's bar is not going to be out there attacking everybody for perceived violations. But having said that, there are other ways in which private plaintiffs' lawyers might be able to circumvent this private enforcement limitation. Okay, now let's go back, if you will, to the first slide. Okay. So now I'll get into who it applies to, because now you've determined, hopefully, whether you are covered or not. Most of you will be covered, I think, unless you're so small and collect so little data that you're out from under just definitionally. It's going to apply to California residents. Very broad definition, as Susan mentioned. It's anybody who enjoys the benefit and protection of laws and government of California. Whatever that means. Somebody who enjoys the benefit and protection of laws and government of California. That could be pretty much anybody who is even passing through, except for the carve-out that they have, that it doesn't cover somebody who's here on a temporary or transitory basis. Again, not sure exactly what temporary or transitory basis means, but it's essentially an incredibly broad statute. More importantly, from a practical perspective, how do you determine if somebody is a California resident who's enjoying the benefit and protection of laws of California? Just because they're buying a property here doesn't necessarily mean that's the case. Just because they are residing here at the time that they apply for a loan doesn't necessarily mean that's the case. So we really need some clarity or more clarity there, which is one of the things that the CMBA and other trade associations are trying to get legislatively, or failing that through the AG's office. Next slide, please.
And actually, we're gonna, John, we're gonna need to wrap it up and move on to employment law.
Okay.
So
I will finish up real quickly. Information is okay. That's enough. I really covered primarily the ones that I wanted to cover anyhow.
Excellent. Thank you so much, John. I know that's a very, very broad topic to talk about, and certainly we're going to be seeing, I think, that being grappled with in the courts for a very long time to try to figure out that clarity, that exactly what you're talking about. A very similar broad topic, and I will mention before we get into this that one of the things we're working on this year is having a webinar expressly devoted to this, which is the topics in employment law and the developments there. So Natalie Vance from Klinedinst has agreed to take on the similarly difficult task of tackling those topics in 15 minutes. So Natalie, if you want to go ahead and take it away and close us out here.
I sure will. So I am going to be talking about some of the new laws that have come into being for 2019 and just quickly get you updated on some of the new statutes that may impact your business going forward. I want to start with talking about some new Me Too laws. As you may be aware, sexual harassment has been in the news. You've probably seen a lot about it, and that has led to a lot of legislation. The California legislators were very busy last year in taking a look at beefing up sexual harassment laws, and there have been a number of laws in place. Next slide. So first of all, there are new training requirements for sexual harassment. Previously, sexual harassment training has been required for employers who have 50 or more employees, and they're required every 2 years to ensure that the supervisors have 2 hours of sexual harassment training. Starting in the year 2020, there are going to be new requirements which will impact businesses with as few as 5 employees. And not only will the 2-hour supervisor training be required, but all employees, non-supervisors, will be required to have at least 1 hour of sexual harassment training. The DFEH has been tasked to create and provide a training course, so there should be a course that's available from the DFEH to provide to both supervisors and non-supervisors that will be free, which will be a benefit to employers and ensure that all of the requirements of the training are met, but that won't be available for some time. DFEH moves pretty slowly. As far as harassment training goes, employers are not authorized, are authorized but not required to provide bystander intervention training to employees. So this is something that the law doesn't require, but does authorize employees to provide. In other words, it encourages employers to provide training to all of their employees regarding bystander intervention. And what that is essentially a policy of if you see something, say something. And it essentially deputizes all employees to take action if they witness sexual harassment or discrimination in the workplace, as opposed to doing nothing and perhaps contributing to a toxic work environment. The sexual harassment laws themselves under FEHA have been amended to include some additional language, which is going to make it harder for employers to defend sexual harassment claims when they're brought in litigation. Specifically, there is now language that states that sexual harassment cases are, quote, rarely appropriate for disposition by summary judgment, end quote. A summary judgment motion is a tool that we have in defense of sex harassment claims, which allows us to go to the court and ask the court to dismiss a sexual harassment claim if the undisputed facts demonstrate that the claim does not rise to the level of sexual harassment under the law. And this is a commonly used practice that does lead to dismissal of claims where the harassment itself is not considered severe or pervasive enough to qualify as harassment under the law. Unfortunately, with this language, it's going to be more difficult There's a totality of the circumstances test for whether or not harassment is severe or pervasive, and language in the statute which notes that a single stray remark could be evidence of discrimination or harassment. And typically we've gotten cases dismissed based on the fact that a single stray remark does not equal to severe or pervasive harassment in the workplace. Also, the plaintiff is required to prove that the sexual harassment has so altered the work conditions that they're unable to perform their job duties because of the harassment. And that has been amended to note that the plaintiff is not required to prove that their productivity has declined or to demonstrate that there are altered work conditions. It's enough simply to prove that a reasonable person would find the harassment altered the working conditions so as to make it more difficult to do the job. And so that's a much more wishy-washy standard where a plaintiff just needs to show that a reasonable person would find it difficult to do the job in light of the harassment that's occurred versus an actual decline in productivity or issue with performing the work. There is a new sexual harassment law which now prohibits confidentiality agreements in connection with the settlement of lawsuits for sexual harassment or sexual discrimination, except for to protect the claimant's identity or non-factual information. It's a very common practice for employers who settle sexual harassment claims to include confidentiality in the agreement. That is to protect the confidentiality of the settlement itself. Employers often don't want other employees to know that they have paid someone. They certainly don't want someone to know how much they have paid. The good news is that the amount of a payment may still be kept confidential. It is considered non-factual information. What this law is targeted towards is to prevent claimants from not being able to speak about the harassment that occurred, and also to encourage employers to be able to speak about the harassment claim in the future in the event that somebody calls them about the alleged harasser and wants information about them in connection with another job. In connection with this, there's also been an addition to the litigation privilege, section 47, which provides that certain communications are privileged. It has always held that you're privileged to discuss whether or not you would hire or not hire someone back, and it includes language in that statute to add that it is privileged for an employer to provide information to another employer about a sexual harassment claim against a former employee. Now, it's a qualified privilege. It's not a complete privilege, so you have to have a factual basis for making the statement, but an employer can now provide information to another employer about a harassment claim that was made against a former employee. The salary history law has been amended. Last year's law on banning salary history inquiries from applicants has now been amended to clarify a few issues that employers have been having difficulty with. First of all, it's made clear that employers may inquire about the applicant's salary expectations for the position in an interview. So it's okay to ask someone what they expect to receive in the position. You cannot ask them what they were paid in their current or prior positions. And also, the law has been clarified to advise employers that although you are required to provide a pay scale after completing to an employee, you're not required to do it until after completing the initial interview. So previously, you were told that employers were required to provide a pay scale for applicants for a position. Now it's clear that only applicants who have completed an initial interview are entitled to receive a pay scale for the position. It also clarifies that as an employer, you're not required to provide that pay scale for the position to current employees. So it's only to applicants who've completed an initial interview. The lactation accommodation statute has also been amended. In California, employers must accommodate lactating employees by providing a private location in close proximity to the employee's work area for the purpose of expressing milk. So previously, the law stated that an employer had to provide a location other than a toilet stall for that purpose, and now it's been clarified that the location has to be other than a bathroom. So it's not sufficient to provide an area within a restroom for a woman to express milk. Instead, they must designate a separate area. And again, it has to be in close proximity to the workplace of the employee. There is a provision which does allow for exceptions for undue hardship, but that's very limited and typically very difficult to establish. Request for inspection of records has also been amended. Employees have always had the right to review their personnel and payroll records upon 21 days notice, and the statute's been amended to note that employers must now provide copies at the employee's request. Previously, employees were entitled to review the records and could make their own copies. Now, employers are required to provide copies and make those copies themselves. All right, and lastly, the minimum wage update. Every year, the minimum wage has been changing, and so it's just a reminder to be aware that the minimum wage changed as of January 1st and is also changing not just across the state, but in many cities that have separate ordinances which provide for a separate minimum wage if you have employees that work in those counties or cities. So do take a look at the city ordinances where you have employees to ensure that your employees have all received the appropriate minimum wage for 2019, and also be aware that this can also impact exempt employees, because exempt employees are typically required to be paid at least double the minimum wage. And so not only do you have to ensure that your lowest level employees are receiving the proper hourly wage, you want to make sure that your exempt employees are also receiving the appropriate minimum wage going forward. And just a reminder, some counties that have their own minimum wage in cities, San Francisco, San Jose, San Diego, Emeryville, Los Angeles, and some other cities in the Los Angeles area also have their own minimum wage. You should be looking at every local community where you have employees to see if they have implemented a minimum wage that is different from what the state requires.
Excellent. Thank you so much, Natalie. If we can move on to the next slide, perfect. So I again want to thank all of our presenters today. This was phenomenally interesting, a lot to unpack here. This is yet the first of many webinars that we'll be covering, I'm sure, many of these topics throughout the year as we get more clarity on what's happening. In the meantime, if you have any questions for any of the speakers, feel free to reach out to them. We're running a little bit over time, so certainly, people are, of course, are free to drop off, but if our speakers don't mind, we'll still stay on a little bit for those that would like to ask questions. And I'll kind of start it off, and I'll shoot it over to Elizabeth by asking, with the situation in your case where the Ninth Circuit has effectively held that a TILA rescission is, subject to whatever state law applies, we do have the situation where virtually every single state's going to have a different statute of limitations. Are we really saying that, for example, in California, a borrower could wait and effectively have a 7-year interest-free loan with their rescission rights?
It would probably be a 4-year interest-free loan, because the interest only stops accumulating when you send in the notice of rescission, not for all the time before you send in the notice. But your larger question, you're absolutely correct. It kind of makes for a patchwork enforcement of a federal statute, which to me seems not ideal. But the general rule is that's what you do when Congress doesn't pass a statute of limitations. You're gonna necessarily get a patchwork, except for that one sort of narrow exception I mentioned that has been applied in the RICO context and not many other times. I've often thought that seems like a silly rule to me. Why wouldn't you go start with a federal statute and try and find a federal analogy, and only then, if you can't find a federal analogy, then you can go to the state, because that would result in more uniform enforcement of federal statutes nationwide. That's not been the rule that the U.S. Supreme Court has followed. The only real argument I can think in favor of it is if you think about the way lawsuits are typically brought by plaintiffs. They usually have a mix of state law and federal law claims. Occasionally you'll have only one or the other, but in a federal lawsuit, it's usually one or two federal claims and 3 or 4 state claims. And if they're very similar, the federal claim is very similar to some of the state claims, you would maybe want them to all have the same limitations period on them. However, that's not that great of a justification in my view. But unfortunately, that's the default way that that the situation gets addressed, not just for TILA.
Excellent. It's going to be very interesting to see how that plays out. I think it is kind of bizarre to see, these varying statutes of limitation being applied for a federal claim that you would think would be uniform throughout the country, but clearly
Absolutely.
not.
Yeah.
Jared, we do actually have another question that I'd like to share. This would be for Natalie. The question is, are the minimum wage laws applicable to the municipalities based on the employer's location or the employee's residence?
It's based on where the employee works. And so you have to be very careful if you have outside salespeople that travel into, for example, San Francisco to work. Then the San Francisco minimum wage ordinance would apply to them. So it's not necessarily where you have your place of business or where the employee lives, it's where the employee goes to perform their work.
Okay, thank you. One last question that we have at this point, and Elizabeth, this is back to you. Are we certain that rescission only starts from the date of demand by the borrower? I thought the CCPA specified that rescission of interest was from the origin of the loan. Elizabeth, I don't know, maybe Elizabeth could have possibly dropped off. I think
I'm sorry. I apologize.
Oh,
I'm here. Sure. I had my mute button on. Sorry.
On mute. Okay. Yeah, no worries.
The speaker may know better than I do. I always thought that that you stopped accumulating interest and fees as of the date you gave notice of rescission, not as of the date of origination. However, I could be wrong. So if the speaker knows better, or the question asker knows better, by all means, that could be right.
I think it's the date of origination, because in a rescission, you're supposed to put the parties back to where they were at the time of the transaction initiated.
Right.
That's right. I concur with that, John.
Okay. Thanks for correcting me.
Okay, and I think that about wraps us up. Thank you all for these great presentations. Really appreciate that. This recording, as all of our webinars, the webinar is being recorded, and it will be available on our website in the next few days. Just one last reminder for those of you that can make it to Sacramento, we are having our annual legislative day on Monday, March 18th. And there's information for registration on that on our website. And I want to give one last thank you not only to our Legal Issues Chair, Jared Eade, but to all of today's speakers, and certainly to our sponsor, Wiener Brodsky Kiter. And thank you all for joining us today. Take care.